Hello, I'm Bill Peterson, Minnesota estate planning attorney. My mom and dad had passed away, leaving behind the family cabin, among other things. Now that summer has finally arrived, the family cabin on Round Lake is ready for fishing, water skiing, and canoeing. But there's a problem. Your stepsister Marilyn, who is the personal representative or the appointed executor of Mom's estate, and her children are using the cabin and not letting other siblings use it. When you call your stepsister to complain, she says that you and your kids can use it for a week when she's done using it for the month of July. You tell your spouse, and you are both very angry with your stepsister. Now, what can be done? Well, in the short run, your stepsister is serving as personal representative for the estate that was left behind by your deceased mom and dad. Marilyn is what we call a fiduciary for you and your brothers and sisters. This means that she must administer the assets, including the lake cabin, for the best interests of the beneficiaries. And when we're talking about beneficiaries, we're talking about you and your brothers and sisters. As a general matter, while the family cabin is part of the estate, it should be administered for the benefit of all the heirs. Now, reasonably, this should mean that the family members should have equal opportunity to use the cabin, the boat, and the other equipment. However, oftentimes this can be easier said than done. If it comes to enforcement of the fiduciary obligations of the personal representative, of course the best choice is a peaceful agreement between the siblings. But when that doesn't happen, or when the agreement falls apart, sometimes a court hearing and a court order may be necessary. All right, once the use of the cabin for the summer is worked out, more questions need to be answered. Will the cabin be sold? Will it be put in the name of all the heirs? How will you determine who gets to use the cabin for particular weeks or weekends during the summer and fall? Who will pay the taxes, or the insurance, or even repairs such as replacement of the roof? What if one of the heirs can't or won't pay his share? What if, for example, your sister Mary divorces that deadbeat husband of hers, Fred? Will Fred have the use of the cabin as well? What if brother Tom has credit problems or even bankruptcy? Will Tom's creditors get a share of the cabin? These and many other issues can face the family, really, when all you want to see is that children and grandchildren and hopefully great-grandchildren enjoy the family cabin just like mom and dad did when they were kids. Now, to preserve family harmony and keep the cabin in the family, you may want to think about setting up a legal organization of your family members for these purposes. Now, you could sell it to a family member who signs a contract which, among other things, can make it available to family members and can apportion the expenses during the year. You may sign it over to all family members as tenants in common. Now, this is a simple step, but it may not give you the protection you want. You may want to set up a family limited partnership or a limited liability company. These two choices are similar and can provide the greatest level of protection, not only to keep the cabin in the family and be sure that the expenses and upkeep matters are taken care of. The family cabin is a great Minnesota tradition. Let me help you keep it alive in your family. I'm Bill Peterson, Minnesota estate planning attorney. Call me toll-free at 1-888 910-5297. I'm looking forward to your call.